Hi everyone, welcome to the mini lecture on the intentional interference with Chattels torts. I have a slideshow, so let's jump straight into that. I'm going to do this so that we can see each other. There. Uh, if you've done the readings, you know there are three such torts, but before we get into what those torts are, let's first of all make sure we're clear as to what a chattel is. I assume you've talked about this in property, but if not, I'll just quickly mention that a chattel, for our purposes, is just stuff, right? There are lots more technical rules around what chattels are and what they aren't, the differences between chattels and fixtures. But for our purposes, suffice it to say, chattels are those things that aren't real property, like land or things that are affixed to land. So we're talking about stuff. We're talking about your rights to stuff or your rights against interference with your stuff. So our interference with chattels torts are trespass to chattels. We're not going to talk a lot about trespass to chattels. This tort should look familiar from trespass to the person, also known as battery, and trespass to land. It's an intentional interference with chattels, a direct and intentional interference with chattels in the possession of the plaintiff. And I actually have a handout with all the technical details distinguishing these three torts. So I wouldn't worry too much about that for now. We're just going to make sure the basic concepts are all clear at this point, and I'll have a really helpful handout for you. So, trespass to chattels, as I said, a direct, intentional interference with the chattel to which the plaintiff has a right of possession. I'll come back to possession in just a minute. No, actually, you know what? Let's skip ahead and then I'll go back to the other torts. So, what is possession? Again, I assume that you'll have talked about this in property law. For our purposes, we don't need to be any more detailed than to say possession in law refers to actual possession, meaning you have actually you actually have control over something, and the intent to possess it. So that's what possession means. And for most of these torts, the owner, oh, there goes my cat, doesn't have to have possession necessarily, so long as there's an immediate. Well, an owner doesn't necessarily have possession or an immediate right to possession. So the point here is to note the distinction between ownership and possession. So, for example, if I own apartments and I rent them out, and then I neither have possession of the rented out premises, nor do I have an immediate right to possession because the tenant has the immediate right to possession. So, just to be clear, ownership and possession are not the same thing. Also, note that there are better and worse possessory rights, right? So, if someone steals my laptop from me, then I have a better possessory right than the thief, but the thief has a better possessory right by virtue of having actual possession and intent to possess than anyone else other than me. So I have a note here to see note 2 on page 125 in terms of the hierarchy of possessory rights. But for now, we're going to go back. So those with possession, or perhaps a right of possession, can bring an action in trespass to chattels. Again, this is made a little more clear in the handout, so I wouldn't worry too much about this now. The second tort, the most important of the three by quite a bit, is the tort of conversion. And I want you to take a minute, pause the video, and try to express in words what the difference is between trespass to chattels and conversion. So again, what is the difference between trespass to chattels and conversion? pause the video here and try to answer that question. While they're both intentional torts involving interferences with chattels, so there's no distinction on the basis of intent or the fact that they have to do with chattels. The main difference, the difference that we're going to be most interested in at this point, is the nature of the interference required for a conversion. You might wonder, why do we have all these technical torts for dealing with your stuff? I mean, some of it's just historical accident. We probably don't need a trespass to chattels tort anymore. Or arguably we do for those interferences that are less serious. But regardless, due to the history of torts, we do have these different torts, and it's helpful to know what their differences are. And in knowing those differences, you can choose which one or which ones to sue in. I mean, it could be that a fact situation encompasses more than one of these torts, in which case you can sue in more than one, or you can elect which one. But you don't necessarily need to pick just one. So, conversion. The difference between a conversion and a trespass to chattels is that a trespass to chattels can be any kind of interference with the chattel, so long as it's direct and intentional. Whereas for conversion, the interference has to be a serious one. Conversions are usually things like theft or destruction, intentional theft, intentional destruction. And conversion is often therefore said to be an interference that is so serious that it warrants making the defendant pay the full value of the chattel as a remedy, as damages. So not any interference is a conversion. It has to be a serious one. We had two cases involving conversion in the readings. One was Folds and Willoughby, and the other is the Bank of Montreal case involving the numbered company. Perhaps before getting into Folds and Willoughby, I'll just mention that the Folds and Willoughby mentions the tort of trover, and it may show up in the readings as well. You can forget about trover. Trover is just the predecessor to the tort of conversion. Trover is no longer an existing tort, so you don't need to know it because it's not good law in Canada anymore. The law of conversion has replaced it. But I just mentioned this because the word does sometimes show up in the readings, and now you won't be confused when it does. Folds versus Willoughby. I'm not sure the facts are entirely clear from the handout I gave you, or the reading I gave you on Twen, but there's a slightly different excerpt on page 127 of the casebook, so you can check that out if you want, although I think there's a decent amount of overlap between them. But just in case there was any lack of clarity, I'll briefly go over the facts. Right? So a man and his horses were boarded a ferry and were going to cross, and the man who came aboard with his horses was behaving very badly, and so the ferrymaster wanted him to leave, and the man who was behaving badly, the plaintiff, refused to leave. And so the ferrymaster removed his horses from the ferry, assuming that the man would follow his horses and disembark. But he didn't, and he ended up going, I believe it was to Liverpool, and left the horses behind. And so now the horses ended up in the possession of a family member of the defendant being the ferry operator. And so some relative of the ferry operator ended up in possession of these horses, and when the plaintiff sought their return, the defendant refused unless money was sent for the keep that they'd had, the food, etc. And when that didn't happen, the horses were sold. So this action is for compensation for the horses that the plaintiff no longer has. So, what's relevant about this case for our purposes is it really talks about the difference between a conversion and a trespass to chattels, although it doesn't always use that language. The trial judge originally found that there was a conversion here, and this was overturned on appeal. The court said um, every law student knows that a conversion requires a certain kind of interference. An interference, I've framed it before as one so serious that it warrants an award of full damages. In Folds and Willoughby, I believe they also refer to it in terms of the interference being inconsistent with the plaintiff's right of possession. Um, some people, again, tend to refer to it in terms of examples like destruction or theft. But I think the best way to think of a conversion is so serious an interference that it warrants the full value of the chattel in damages. And that's what had happened at the trial level here. The judge had awarded £40 to the plaintiff, the value of the horses. Again, overturned on appeal. The court said no. There was no interference inconsistent with the plaintiff's right of possession. They weren't stolen, they weren't destroyed, they were moved onto shore, and that the judge on appeal says constitutes essentially a trespass to chattels. Mere asportation is the language they use, but you can understand that to just mean any sort of interference, any sort of touching. That the interference here was sort of a touching, a moving, but not one so serious. It didn't result, that it's in itself didn't result in the loss of the horses. And so there was no conversion, and therefore the appeal succeeded. Now, probably there could have still had the plaintiff could have had a successful action for trespass to chattels, but the damages would have been lower. It's true that the horses were ultimately lost to the plaintiff, but that is arguably his own fault for not having sent for them and paid a small amount for their upkeep. So, conversion requires a very serious interference, and that sort of interference is not to be found in Folds versus Willoughby. The other case we saw in conversion is 373409 Alberta Limited. This is the second or third case we've seen now that has a title like this with a number and then a province name. We saw this in Huron Steel, I believe. And that's just a way of naming corporations. If you don't want to actually come up with a name, there's sometimes hard to come up with a name for corporations because they have to be distinct from other corporate names, and there are other rules that apply. And if you don't want to do that, you can just take the next number on the list and be corporation number whatever, New Brunswick. So this is 373409 Alberta Limited versus Bank of Montreal. Again, I think the facts are clear enough here, but it's worth teasing them apart a bit because they're really important. So there was a sale of, I believe it was a car, to the numbered by the numbered corporation. The numbered corporation owned a car, sold it to someone, received a check in payment, and that check was made out to the numbered corporation. That numbered corporation is owned, and the sole shareholder and director of that corporation is a man named Lacusta, Douglas Lacusta. And he owns that corporation. He also owned another corporation called Legacy. As it turns out, the numbered corporation was just about bankrupt and was about to go into receivership. And had that happened, the proceeds of the sale of that car would have gone to creditors, right? That would have been lost to Mr. Lacusta. It would have gone to pay the debts of the corporation, the numbered corporation. So instead, what Mr. Lacusta did is he crossed out the name of the numbered corporation and instead in its place wrote Legacy, which is the name of his other corporation, which was not in receivership. That means the proceeds went to this other corporation and were not available to pay the creditors of the numbered corporation. Now, he's not allowed to do this, right? This is illegal, essentially, to avoid paying your debts in this way. But that's not what this case is about. This case is about creditors of the numbered corporation trying to recover the proceeds of the car sale, essentially from Bank of Montreal. And they've alleged that the Bank of Montreal converted the check that was written to the numbered corporation and deposited by the Bank of Montreal into Legacy's account. And the plaintiffs claim that doing this converted the check because they treated it in a manner inconsistent with the owner or possessor's possessory rights. They argued that the simply authorizing the check to be deposited to Legacy by scratching out the name of one company and writing in the other was not sufficient to transfer title, and therefore this was a conversion. So you'll probably recall that the court said it was not a conversion. Pause the video now and see if you can remember why exactly it wasn't a conversion. And I know these facts are a little bit complicated, but again, it's important to understand what conversion consists of. So for what reason was this not a conversion? So the court said it wasn't a conversion because a conversion requires, again, an interference inconsistent with the owner or possessor's rights of possession. And in this case, the court said the Bank of Montreal was authorized by Mr. Lakutsa to deposit the money in Legacy's account. And Mr. Lakutsa, as the directing officer, the sole shareholder of the numbered corporation, was entitled to authorize that. So they were acting with proper authorization from the possessor and owner of the check. So they were not acting inconsistently with those possessory rights. They did. There was no conversion. So hopefully that's fairly clear. And we'll come back to the issue of remedies and different remedies, which comes up a bit in the readings. But for now, we're just sort of trying to get our head around the elements. So we'll move on to the third tort of intentional interference with chattels, which is détenu. This is a very specific tort. It doesn't arise a lot, but it does fill an important gap that would exist if détenu weren't a tort. Détenu, as you know from the readings, is a wrongful refusal to return a chattel when the person with the right of possession requests it to be returned. So you ask someone to return your thing and they don't. For example, if someone were to steal my laptop and I asked for it back and they refused to give it to me, they have then committed a détenu. Now, I'm not sure if this was in the readings or not, but I'll just mention that it's not always necessary in détenu to request that the item be returned if it's clear they're not going to return it. So with theft generally, you don't need to ask for the return of the object because presumably they're not going to give it back to you just because you ask. But where the request really is important is in those more innocent cases, or cases where the person you're requesting the item from has lost possession of it. So for example, imagine that my watch is broken and I take it to a jeweler to get repaired. We've now got a bailment relationship. We probably talk about that in property, but in any event, the jeweler now has possession of my watch and has lawful possession of my watch for the period of time it takes to fix it. So I come back a couple of weeks later, I go to pick it up, I request its return, and for some reason they can't find it. It's been misplaced, it's been lost, or perhaps someone else has stolen it, but through no fault of the jewelers. Um, at that point, I've asked for its return. They're unable to return it, which also means that they do not return it. Effectively, they refuse my request. And at that point, we've got a debt new. And again, it doesn't matter whether this was whether they lost possession wrongfully or not. It's still a debt new. And debt new begins at that point that you've requested the object's return and it's not returned. What else about debt new? It's an ongoing tort. So long as the chattel is not returned, the debt new is ongoing. So that's important for things like limitations periods. The clock doesn't start running for limitations periods because the tort's ongoing. Another thing that follows from all this is that if somehow the watch is rediscovered and is then returned, then you no longer have an action in debt new because there's no longer a refusal to return it. So you no longer have a case. But of course, you would have a trespass to chattels claim. Okay, let's move on. Oh, the readings mentioned the action on the case to protect the owner's reversionary interest. We're not going to talk about that. It's not examinable. It doesn't arise very often, so I just mentioned it again in case you noted it and were wondering why we're not talking about it. We talked about possession already. We talked about Folds and Willoughby already. Trespass to chattels may lie for mere touching or movement, but conversion requires something more, exercising possessory rights over the chattel, or another act inconsistent with the plaintiff's possessory rights. I know this is getting repetitive, but repetition can be helpful sometimes in learning these new concepts. Professor Prosser, who was a well-known tort scholar in the U.S., identified certain factors that might point in the direction of conversion. It's a bit like the factors in nuisance that we talked about, right? Severity, utility, character of the locale. Similarly, these are sorts of things that might be relevant to the question of whether you have a serious enough interference to constitute a conversion. And those are the extent and duration of the exercise of dominion or control. So a very brief exercise of dominion or control might not constitute a conversion, whereas a longer one or a more complete one might. The good faith of the defendant, that's an interesting one. It's not obvious to me. Well, I suppose it might relate to, it's not the same thing as intent, right? So you need to intend a conversion, but there are lots of ways of intending a conversion without doing anything wrong. Remember we talked in Trespass to Land about you can intentionally trespass to land without realizing that you're on someone else's property. So in that sense, it's not blameworthy. I mean, similarly, if I buy a TV on Kijiji and it turns out that TV was stolen and sold to me, then in buying it, I've committed a conversion. And if I were to sell it along to someone else or give it to someone else, again, a conversion. And so that's all intentional because I've intended to buy and sell. But there I'm acting in good faith. Suffice it to say that good faith isn't going to get you out of conversion in a situation like that. Again, the readings indicate that that honest buyers and sellers still convert if they are the victims of someone who's dealing in stolen property. The harm done to the chattel. This, I think, is going to be the most important one, right? Destruction, loss. If the chattel can no longer be returned, if it's damaged significantly. Oh, here comes the cat again. All right, hold on. You're going to have to move. Say hi to everybody. There we go. Okay, bye. There you go. Just seeing if you're paying attention. So obviously, the more harm done to the chattel, the more likely you've got a conversion. Whereas if there's only very minor damage, it may only be a trespass to chattels. The expense and inconvenience caused. So again, the more expense, the more inconvenience caused, the more likely the interference is to warrant paying the full value of the chattel in damages. And again, and the courts also sometimes refer to conversion in terms of a forced judicial sale, right? So that's the same idea as saying it warrants paying the full value of the chattel, right? It's as if you forced a sale from the plaintiff to the defendant, and now the defendant has to pay for the value of the chattel. And so the final bullet makes precisely that point. The question is essentially, is a forced judicial sale warranted? Should the defendant have to pay the full price? We talked about the numbered corporation. I didn't so much touch on the idea of endorsement versus authorization, but I think it's clear from what I said about Mr. Lakutsa having authorized the bank to treat the chattel, the check, in a certain way. The court had argued that the plaintiff had argued that endorsement was necessary in order for the fact that the bank deposited the check in Legacy's account not to constitute conversion. Okay, that was a sentence that was hard to follow. They said only if there's endorsement is the bank entitled to deposit it in Legacy's account without it constituting a conversion. And the court said no, they had authorization from the person who was entitled to give it, and that was Mr. Lakutsa. So it's not conversion to pay out a check to someone if the person with possession or the right of possession authorized it. One final thing I want to talk about. Okay, yeah, she doesn't like being left out, this one. This is why I can't do my grading at home. She just wants to swat the pencils away. Remedies. Again, this was mentioned briefly in the readings. Because the nature of these three torts is different, the remedies vary. Trespass to chattels, if there's no damage or loss of the chattel, then the remedy is likely to be nominal, just like in the HBC versus White case. In conversion, I've said far too many times now already that the remedy is the full value of the chattels. And in detenue, the remedy would also tend to be the full value of the chattel, but measured at a different point in time potentially than conversion, because the date of conversion is the time at which the defendant treats the plaintiff's chattel in a manner inconsistent with the plaintiff's right of possession, whereas the detenue is ongoing, takes place up until the moment the chattel is delivered. And so if there's a difference in value over the relevant span of time, you can select your action in conversion or detenue, depending on which would get you more in damages. I guess one other thing to note about remedies is that in detenue, it's possible sometimes, instead of damages, to get an order for the return of the chattel. And some sources say that that's a typical kind of remedy. Others say that is fairly rare and only happens with chattels that are special or unique in some ways, like a family heirloom or a piece of art. So it's not clear that you can always get the item ordered returned, but to the extent that you can, it's only in detenue, certainly not in conversion. So I think that's it for this mini lecture on the three intentional interference with Chattels torts, and we'll try some problems when we next meet. Take care.